The House bill, I meant. We'll now hear HB 1089. Representative Kofalt.
Thank you, Mr. Chairman, and thank you, members of the committee, for hearing my testimony. House Bill 1089, I'll be very brief. I think this is a simple bill. Essentially, this came up as due to concerns about the fact that a number of people had been told that if they don't get a COVID-19 vaccine, they will no longer have a job. And one of the things that we saw was that there was not necessarily a clear direction set by the legislature with respect to what that means relative to non-compete agreements and termination at the will of the employer. So essentially, all this bill does is it adds to statute regarding non-compete agreements and the enforceability or lack thereof regarding non-compete agreements by stating that a material change to the terms of employment constitutes a termination at the will of the employer, and that if a medical intervention is required as a condition of employment, and that if an employee is terminated because of their refusal to comply with such a mandate, that the non-compete agreement would be unenforceable. All other agreements, including non-disclosure, confidentiality, trade secrets, intellectual property, etc., would still remain in full effect. This essentially was just similar language to what is found elsewhere in statute with respect to non-compete agreements. So essentially, it just states that non-compete agreement is unenforceable under those circumstances. That is, if an employee is terminated for non-compliance with a medical intervention, which is presented as a condition of employment, and that this is termination at the will of the employer. And yeah, that's essentially it.
Great, thank you. Questions? So you see this as the mandate for having a vaccine as a unilateral change in the contract that the employee did not agree to when they signed on, and therefore when they signed the non-compete agreement and then the contract was changed by the employer and would make the non-compete null and void. Is that what you...
That is correct. And in fact, there is legal precedent both in New Hampshire and in other states to support this principle that a material change in the terms of employment renders a non-compete agreement null and void. There was one case in which the assets of a business were sold to another party. The other party significantly changed the compensation structure, made it based much more on commission and much less on a fixed salary. And the courts found that in this case, it was the non-compete agreement was unenforceable because this really was a material change in the terms of employment.
Yeah, I've seen it. Thank you.
Okay.
Thank you very much.
Thank you.
Dave, Jarrett?
Thank you, Mr. Chair. Could I, with your permission, ask Andrea Chatfield, who's also signed up to...
You absolutely could. And anyone else you want. We'll have a whole group.
Thank you, Mr. Chair. For the record, my name is Dave Juvet. I'm a Senior Vice President with the Business and Industry Association. I'll allow my colleague Andrea to introduce herself when she speaks. I will start. I want to give a little bit of history. In fact, going back, I don't know, maybe 8 years or more. Senator Soucy, you might remember this, others might, but there was a lot of work done on non-compete statutes in the state. And what prompted that legislative work was the feeling that non-competes were too much in favor of the employer, and that it boxed employees in to employment in a way that they felt like they could never leave because of the non-compete agreement. There was a lot of work done. There were a lot of people at the table. Employers were at the table. Labor was at the table. Both sides gave in a little, and we arrived at what I think is a relatively balanced non-compete statute for the state that doesn't heavily favor employers or labor. I think we're in the right spot. So we were initially concerned about this bill, but became really concerned by what happened in the House. The original bill focused specifically on COVID-19 vaccinations and said, as the previous testifier indicated, if the employer implemented a COVID-19 vaccination and the employee refused to comply and the employment was terminated, any existing non-compete that they may have had would be rendered null and void. Representing employers, we weren't particularly happy with that, but we didn't strongly oppose it either. It was very narrowly focused. But for reasons I'm a little mystified by, the House Labor Committee voted to radically change that legislation is introduced, and what you see is the result. And I want to add that although they certainly have the ability to do this, the amendment changing the bill happened in the executive session for the bill. Advocates such as myself and others had no advanced knowledge of the language. We were not asked if we saw any problems with it. It was introduced in the executive session and quickly passed, and it was off to the full House. So we think there are significant problems with this amended version. In fact, we think it turns non-compete statutes in New Hampshire on their head. And it is because of that phrase, primarily, material change in employment, which you will see the bill passed by the House does not define. It does say that what they call a medical intervention, and I don't know if that's meant to mean vaccines. I suppose it could also mean emergency medical assistance if you collapse in the office. It says that is a material change in employment, but it doesn't say what else is a material change in employment. And when you think about it, there are a lot of things that could include. It could include a change in salary. It could include a promotion. It could include almost any. It could include changing offices or, moving from one side of town to the other. There's a lot of things that it could include. And by not defining that, it will, without question, lead to litigation between employers and employees. So we are asking that you look at that carefully. I will turn it over to my colleague, Andrea Chatfield now, but I do want to let the committee know, we hope you will kill the bill. We don't think it's good. We met with Senator Bradley, and he was asking, well, are there ways to fix it? And we agreed to provide Senator Bradley with an amendment. I can't say it's an amendment that BIA would support, but it is an amendment we could live with. And it's going to go very similar back to the original language of the bill, but clean up a little bit things that were not in the original bill that we are thinking are important. So Senator Bradley and we are working on that amendment, which you'll see at some point in the future. But again, our preference would be to just kill the legislation. So let me turn it over to Andrea Chatfield.
Okay. Thank you, Dave. My name is Andrea Chatfield, and I am here to support Dave in the BIA, but also I'm here to represent the HR State Council of New Hampshire. So I'm going to just hand over my written test. I have written testimony, and I promise I won't read it. But I think it's important to highlight several aspects of my written testimony. The HR State Council is made up of over 1,000 HR representatives throughout the state. They represent a myriad in every industry, every type of employer you can imagine, for-profit, nonprofit, public, private, small, medium, large employers. And I'm here to speak on their behalf today in opposition to HB 1089. And we have several concerns. The first, as I think Dave alluded to, is the fact that the term material change is vague and overly broad. Let me give you a really good, I think, eye-opening example of what that would mean. The first sentence of the bill, right, says any material change would invalidate a non-compete. Think back 2 years ago when massive amounts of people in this state all of a sudden had to work from home. That was a material change. That would have wiped out all their non-competes. That's how broad this statute would have been and could be under the wording. So I think that's a great illustration of what we mean by vague and overbroad. Think about the fact that a person gets a new boss. That could be a material change if they have a different way of managing. So the problem for HR people that have to implement non-competes and implement changes in employment is a nightmare if they had to live with this bill. It would be a nightmare. HR people, how would they know what is a material change and what would not be a material change? And how would they know when a non-compete is invalidated? And what do you do about that? So from an HR perspective, this would be a nightmare of a law to try to comply with and try to follow. Businesses need laws that are practical, reasonable, and balanced. And as Dave pointed out, the statute that was enacted on non-competes, I think achieved those three goals: practical, reasonable, and balanced. And this bill is none of those. The other thing I want to bring forth is that the bill undermines the purposes of non-compete agreements. And I understand the concern about, well, if you implement something, it changes your employment contract. But when you are an at-will employee, there's no such thing as a contract. You're employed at the will of both parties. Employers make changes all the times to the terms and conditions of employment. And certainly if a person's been employed for more than a year or for several years, there's going to be a lot of changes they go through. That's not what should determine the enforceability of the non-compete agreement. There's case law about a material change, invalidated non-competes. First of all, in the terms of a sale of a business, a lot of times the non-compete is not automatically assignable to the new buyer or to the new owners. And that can hurt. And that's recognized in case law. There was one case that I know of. I mean, I do a lot of work, first of all, as an employment law attorney, I do a lot of work with non-compete agreements in various states, including New Hampshire. And I know that in Massachusetts, there was a case involving an employee who was able to invalidate his non-compete because of material changes. But that was because he'd signed a non-compete many years ago and had gone through several different job changes and promotions and changes in compensation. And even during that time had been asked to sign a new non-compete and had rejected that. And of course, then under those types of circumstances, yeah, the old non-compete probably was invalid at that point. But this turns that on its head. This just is any material change would invalidate it. A non-compete agreement, I think we do have to remember from a business perspective, is a valuable tool and very necessary. What is it? What are the purposes of a non-compete? Protecting confidential information, protecting the customer goodwill of the employer, and promoting fair competition. And these are valid business interests that have been well recognized by every court in this state, in this country, as legitimate business interests that are worthy of being protected. This law would just turn those upended. If you think about it, consider somebody who's employed as hired as a sales rep for a particular territory. They sign a non-compete agreement. Then they're promoted to a sales manager position. That non-compete, a material change under the statute, but that would then make the non-compete even more important to keep in place. So I can only give you examples to show you what I mean. The other thing that this bill does that I'm really concerned about is it would allow employees to violate non-solicitation provisions. If you notice, non-solicitation agreements are not exempted from this bill, like non-disclosures and protection of IP. And non-solicitation means that an employee cannot go and steal clients once they leave their employment. And that is a restriction that courts have long upheld. The key point here too, so non-solicitations, a person has a material change. Any material change happens to them, they can then leave their employment and steal the customers. And I say that because if you look at the bill as amended, it's just the change that triggers the unenforceability. It's not that the change resulted in termination of employment. It's just the change that results in unenforceability. So then a material change happens, an employee can leave on their own and compete or steal customers. So I don't think that's what was intended, but that is the wording of the bill. And then the bill was also says that it does say that there are new requirements for medical testing, vaccination, and other medical intervention would invalidate the non-compete. Again, once they cut to what does all that have to do with a non-compete agreement or a non-solicitation agreement? They're just not connected. I understand that there was issues with people, perhaps they were told that it's either get vaccinated or lose your job, but this goes well beyond any of that. Consider what any type of new medical requirement could be. Let's say you have an employee who's acting erratically and you want to have them go for a fitness for duty test, exam. That's a new medical requirement, invalidates the non-compete. When you're just, as the employer, trying to be safe, it doesn't make sense to me. I think this bill would really hamper the ability for employers in general in the state. It's not going to encourage businesses coming to this state. If they have uncertainty about being able to protect their customers, their relationships with their customers, their confidential information, then they're not going to want to come here. This is not going to be a business-friendly state. This bill really impairs the employer's ability to effectively manage their workplace. So I'm happy to take questions, but we urge you on behalf of the State Council to please vote this bill to kill it and to say it's inexpedient to legislate. Thank you.
Questions? Thank you both.
Thank you.
The only one I have left is Peggy Gill, does not wish to speak, but she opposes the bill. Does anyone else wish to speak on the bill? Seeing none? Thank you.